Good morning, everyone. Hi, good morning. Thanks for joining us on our event today, our pop up legal update with Mr. Wade. So, this is just a pop up event. We're going to jump in, we're going to respect everyone's time. So, before we get started, I want to just kindly just do a quick introduction of Mr. Wade. John joined Martin and Guilford law firm after founding his own firm and clerking for several judges in North Carolina Court of Appeals. He spent his first 8 years in the firm practicing trial and appellate litigation. He now uses that valuable background to draft forms and give advice and guidance to brokers, real estate firms, local boards, and realtors, and the North Carolina Association of Realtors. In his free time, John enjoys coaching and playing soccer, cycling, reading novels, and spending time with his family. He is also the former mayor of Clemens. Where do you find the time, John? Thank you for joining us, and we appreciate this information you're going to bring to us today.
Thanks, appreciate it. I don't know. I guess I'm selfish enough to make time for the things that interest me, including you guys. I'm gonna go ahead and share my screen here and talk a little bit about. Hopefully, you guys have heard something about this settlement. If you have not, we're going to cover that along with some other things in detail. My name is John Waite. I'm an attorney. I am, general counsel to NC Realtors, but we're a law firm in Winston-Salem. And I'm going to talk a little bit more about what our firm does for the state level, but more importantly for today, we are your guys' general counsel also. So it's not basically what you guys get to do is piggyback off of the work that we do for the state association to be able to help and inform you guys on things that you have going on in your local association. We always, use that as best we can to make sure you guys have the most information. But that said, just so you're aware, and I want to make this clear from the beginning, I don't get any special information regarding this antitrust stuff. None. I haven't got any the entire time. Like, basically what I've had to do is look at these cases myself, look at them and read the court filings and things like that, and then try and figure out where I think the case might be going. Interestingly, we're going to be talking about forms changes a little bit later. But just so you know, my confidence level in what I'm going to say today is going to vary. And so I'll let you know when I feel confident about things and when I'm not. But if you want to know where I've been so far, we were supposed to wrap up our form cycle last month. And obviously we had to reopen the cycle once this settlement came out March 15th. And during the form cycle, I made a bunch of suggestions for forms edits to the forms just based on what I was reading in the court filings. And it was really a stab in the dark. I had no idea that they were getting ready to do the settlement. I had no idea, what the settlement was going to say, nothing. I was just reading. And I got it real close. I mean, real close, like 95% close. Now, the forms committee at the time decided it was a bit much. Like, if we didn't have the settlement, that's what, we were operating in a vacuum. We didn't have that context. But they're like, listen, we understand what you're saying, but it's a little bit far for right now without something a little bit more concrete. Well, lo and behold, the settlement comes out, and pretty much everything I asked them to do is what, they really wanted to do, is what we're going to have to do when we reopen. So the good news is that I already drafted a bunch of them. The bad news is that, it was all kind of in theory. Now I'm having to actually go through every single form. We'll talk a little bit more about that later, but just a little bit more about me as far as, context for today. Yes, I used to be the mayor of Clemens. That was when my kids were little. I didn't really have anything better to do. The mayor of my town asked me if I wanted to be the mayor, and I said, sure. I don't recommend campaigning, though. That was one of those things where I'm sure none of you have ever done this, but it was one of those things where it sounded cool, and so I decided to do it. And then the actual heavy lift that it takes to do something like that, it turned out to be biting off a lot more than I thought it was going to be. And by the way, the previous mayor, totally undersold what the time commitment was on that job, by the way. I really appreciated that. I'd shoot him out later for it. Anyway, I did that for 4 years. It's been pretty valuable when it comes to real estate matters and a lot of things you guys have to deal with when you're dealing with county managers, city managers, and things like that. Usually it helps me be able to get some insight on all those sorts of things. As far as my background in the appellate courts, that'll be useful for today. I'll be able to give you some inside information on why didn't we end up with an appeal in this particular antitrust case. We'll talk about that. And yeah, I used to be a high school math teacher and a wilderness camp counselor. Wilderness camp counselor is how I ended up living in North Carolina. My first job back in 2002 was working at a wilderness camp in Elizabethtown. I'm sure you guys know where that is. It's a bunch of pine trees and sand. Anyway, it was fun. It was probably my favorite job ever. No offense to my current job, but living in the woods was way more fun. Anyway, so let's go ahead and let's just back way up before we get like too far into the weeds of what's happening with this case in Missouri and the settlement and all those things. Let's just talk about antitrust. The term encompasses really two different things. They're related, but they're two different things, okay? The first is monopolies. Monopolies might be a little bit easier to understand, right? Because of the game, you understand the goal is to take over everything, right? The goal is to take over everything, choke out your competition, and you win by taking everyone's money, right? That's what Monopoly the game is. That's how monopolies in real life work. That is, sometimes they're intentional and sometimes they're not. So you see, you might read news articles every once in a while. Microsoft got in big trouble a couple of years ago for their web browser, Internet Explorer, if you can even call it a web browser. But anyway, and the reason was because they were using that web browser in order to club their competition. And for a while there, they did a really good job of doing that. Antitrust came along, broke it up, and we got a lot of different kinds of browsers now that are actually infinitely superior to Internet Explorer. And that's the point of breaking up a monopoly, is to do that. Other famous monopoly cases, Standard Oil, AT&T, those companies used to all be one company. They got broken down into smaller companies. Why? To encourage competition in order to prevent one company from fixing prices, okay? But the case in Missouri that we're going to talk about, Burnett versus NAR and a bunch of other people. You guys have hopefully have some context for this, but in the Missouri case, in the Burnett case, NAR was named as a defendant and MLSs were named as defendants. Local boards were named as defendants, as well as big real estate firms. Okay. That was a Section 1 restraint of trade case is what occurred in Missouri. So what happened? Nothing special. If you want to know what the factual basis of the case in Missouri was, there's a regular old MLS transaction, as you guys have been dealing with the MLS for many years. Basically, the seller hired a listing agent. Listing agent put an offer of compensation to the MLS. Buyer agent submitted an offer with their buyer. Cooperating compensation was shared pursuant to the MLS rules. And that was it. That was the whole thing. And so you had a couple of seller plaintiffs in the Missouri case who brought a lawsuit saying that system, the MLS system, inflated the amount of commissions that were paid in the transaction. Of course, you've heard for many years, NAR denied the allegations, said they were wrong on the facts and law, and that they felt confident they were going to win in this particular case. And we could get way down the rabbit hole of antitrust as to why, but I think as far as why these seller plaintiffs were arguing this, but I think maybe an easier way to think about it would be this. And this is actually something we're going to talk about, on the next slide too. But when you're in an antitrust framework, okay, one of the big things you look at is what is the fluctuation of prices? How much do the price of whatever it is, how much does it fluctuate? And in this case, they were looking at commissions. How much do commissions fluctuate and reflect market pressures? For example, in a market like we have now, where it's more of or like what we've had, I don't know if you still have it now necessarily. My guess is you guys probably do, but it's more of a seller's market, right? So the question would be, from an economics perspective, why or should or do commission rates from real estate brokers, do they reflect the market? In other words, are sellers adjusting how much cooperative compensation they're offering because there's so many buyers and there's so many buyer agents? You shouldn't have to offer, a lot of commissions to show your house in a seller market. Now, this is a don't shoot the messenger scenario, okay? I am just telling you what they're arguing, okay? That is what they argued. And in the Missouri case, as well as some of the other antitrust cases, this is not terribly unusual. In this particular case, though, I can tell you that one of the experts who gave testimony about the economics of this particular system, one of their invoices was over $1 million. And the reason for that is because their firm is going through years and years and years of data in the MLS and figuring out not just the Missouri MLS, which was, I think, close to St. Louis, but also other MLSs to look and looking at other countries and how they do real estate. And that's what they did. And that was the sort of their theory as far as why they were saying that the MLS framework made commissions higher than what they otherwise should have been. Okay. Well, as I said, MAR denied this. MAR put their own experts. NAR did a lot of things. But at the end of the day, a jury came back and awarded the seller plaintiffs, almost everything they wanted and gave them $1.8 billion. And with these sorts of cases, you don't just get whatever the jury says. Those damages are tripled, which is called trebled. Don't ask me why. It's just, we just want to be special as lawyers, I guess. I don't know. But the damages are tripled, and then there's attorney's fees on top of that. All in all, you're looking at 6.5, billion, maybe 6 billion, something like that. It's not uncommon to have the attorney's fees be a substantial amount close to the jury verdict. So, what kind of evidence was presented? Firm training materials, and for lack of a better way to describe these firm training materials, some of them could easily be described as how to browbeat your seller into offering cooperative compensation that they don't want to give. Okay, instead of giving your client, the seller, a real option, is instead teaching agents how to bludgeon their clients to death and pressure them into offering commissions that the sellers otherwise don't want to give. And say what you will about that, but that is a problem, and it was something where I know you guys don't want to admit this at all, but at the end of the day, your industry is subject to the same thing as mine, which is to say you're like lawyers and you have bad apples in your bunch. I know you don't want to hear that, but somebody has to tell you the hard truth. And there were some bad apples. And these bad apples got shown in court, which is totally allowed to happen. You're allowed to show the good apples too, and they did. But at the end, I think that you have to understand that the firm training materials were a real problem. I mean, I watched some of the videos, I looked at some of the training materials, and I work in this industry. I believe in this industry, and even I was just like, yeah. Okay, I'm just telling you. All right. Another piece of evidence that was submitted in this Missouri case was minimum commission rates set by firms. I've been telling people as I've been going around speaking across the state on this topic that if you're a firm that sets minimum rates for your agents, then you may want to re-examine that. Talk to your lawyer and see if it's something where it'd make more sense, and if it would be better for your firm, where your firm sets its rate, as in the firm sets whatever its cut is going to be. You have to do that. Please don't confuse me on that. It's just something to think about, and something that you might want to talk to whoever your firm's lawyer is. You may want to talk to them about that and see if that's something that makes sense. Mandatory blanket offers of compensation, the MLS, also evidence. Now, I can't remember if this is on the next slide or not. Forgive me. Yeah. So I'm just going to go ahead and say this now. The reason that this evidence was important, the MLS rules, if you will, as evidence, is because just prior to the trial, the judge made a very, very, very important ruling. And I'm going to talk more about this when I talk about, why the appeal didn't end up going through. But the judge prior to this trial in Missouri made a ruling which basically said that if you touch this rule in any way, then you are going to share in the liability. It's what's called a per se ruling. Per se means that it's kind of automatic, I guess is a better way to phrase it. Another way to analyze it would be a rule of reason, which means that if you're interacting with the rule in a way that makes sense, that is reasonable, then you may not share in liability. Basically, you treat each defendant individually. Okay? Well, that didn't happen in this case. Instead, the judge made a per se ruling. That per se ruling is probably part of the reason why, the jury, in giving this $1.8 billion verdict, they didn't deliberate hardly 2 hours. I mean, it was not long. And the reason for that was in part because of this per se ruling that affected the jury instructions, that affected how the jury was instructed to look at the evidence in the case. Okay? It was a big deal. It's really hard to explain what a big deal that is. And I will give you a personal example. I did a jury trial down in Johnston County several years ago. And prior to the trial, the judge there made a similar ruling where basically my clients were deemed liable. Like, liability was not going to be a question that was going to be determined by the jury. The judge determined on what's called summary judgment prior to trial that my clients were going to be liable. The trial was going to be about just how much my clients had to pay. I'll talk a little bit more about that later because I like the ending to the story. Anyway, so these sorts of rulings are really important. I would say that this judge's ruling was similar to impact as the one that I had in my jury trial down in Johnston County. It was significant. It changes the entire way the case is presented. And for any of you who have sat in a jury, what happens is you listen to all the evidence. You listen to the evidence, like what are the facts of the case. Then the judge gives you the instructions and tells you what the law is. And as a jury, you're not allowed to question that. Part of when you're chosen for jury selection, if you want to get out of jury selection, this is one of the ways to do it. You can just say, I'm not capable of following the law if it's given to me, because that's one of the most important things that a jury does, is listens to what the judge says the law is. If you can't do that, they are not going to sit you for the jury. So if you tell the judge, well, the law is whatever I say it is, and I don't care what you say, that'll be a pretty quick way to get you out of the jury selection process. Anywho, so what was another piece of evidence that was presented in the Missouri case? Steering, buyer agents steering clients toward home with higher cooperating compensation. They were able to show that happens. And I know buyer agents, you don't really want to admit that happens, but it does happen. And I brought this up. No, 1 through 4 on the screen, that was actually evidence in the Missouri case, okay, in the Burnett case. There was a copycat case filed in Texas that will probably end up being settled now because of the broader settlement that we're going to talk more about. But in the Texas case, I thought these stats were kind of interesting, so I've put them on the screen just so you guys kind of know, because I think similar stats were used in Missouri, not exact, but similar. But in the Texas case, the allegations, now these were not proven. These were just allegations from seller plaintiffs in Texas. And that's only 0.5%. That's 0.005, 0.5% or less of sellers offer a buyer's agent commission below 2% in those markets, regardless of the market demand and pressures, okay? And then a large majority, 73% of agents say they will not negotiate their commissions. Again, that was a study. I think, at least in my experience, is probably correct. But the interesting thing about it to me is, what does that stat even mean? To me, it seems meaningless just on its face, just as a pure allegation, because you guys know your worth. You're allowed to charge what you're worth, and you're no different than any other profession. For example, in the legal profession, our rates at my firm, they get adjusted, just like every other law firm. Why did they get adjusted? Sometimes it is purely because, we believe that, our services have a certain value and we put a number on that value. Other times, there's been times where I've looked at our rates and made suggestions on adjustments just because I look at someone else's, invoice and I'm just like, this lawyer isn't nearly as good as me and they're charging a lot more. So it happens. It just happens. And so to me, I don't think it's something, and those sorts of things are not automatically antitrust violations, just so we are clear. What the reason antitrust comes up is when it's widespread and when it is considered unlawful. And is considered unlawful when it is unfair or an unreasonable restraint of trade, which is what the jury found in this particular case, just based on the judge's ruling and the instructions they got. So what happened on the Ides of March? I still want to know if they did that on purpose or not, but I have not got an answer to that yet. Of all the burning questions I have about this settlement, I do not know whether the settlement was purposely announced on the Ides of March. For those of you who know what I'm talking about on that, congratulations on graduating high school English. Anyway, I'm just kidding. So NAR settled the case on March 15th. The terms of the settlement, if you don't really want to pay attention to the details I'm about to give you about what the settlement means, then the TLDR is cooperative compensation, still an option. Okay, it's not going to die or go away or anything like that. It's just going to have to be negotiated more like commercial transactions independently. We are working to try and work commissions into the offer to purchase a contract, which I think is the most logical place for it to go, but that is a commission rule. And I just don't think the commission has appetite to change that rule right now. But if you want to lobby them and let them know that it would make sense. Commissions are already part of the transaction anyway. I don't see any reason to divorce them. And while we're changing commission rules, if you want to let the commission know that maybe shopping offers is not the most horrible thing in the world, and maybe it would be beneficial to sellers to do that, and maybe even to buyers for that matter, depending on the circumstance, then that might be something to consider also. I'm not saying you have to do those things. I'm just saying those are two rules where, to me, the way you guys perform brokerage, those two rules don't make a lot of sense to me. That's just my personal opinion. The commission is allowed to have whatever opinion it wants, by the way. This is not some kind of personal attack. Please don't go saying that I was talking bad about the commission. I am not. They have a particular mission set by statute. They are good at that mission. They do their mission. That's all there is to it. To the extent that they're open to input, those are two things that I would like to see changed if they're open to it. All right. So in the Burnett case, what are the terms of the settlement? First of all, cooperative compensation, including saying what the total amount that the listing firm is getting in the transaction, that will not be in the MLS. And I do expect that all these changes are going to go in effect in July. At least right now, anyway, that's all the information I'm getting. We are preparing as if it's going to be July. Number two, written buyer agency agreements will be mandatory. We do that already in North Carolina, so not a big deal for us. There will be some changes we're going to make to that. I'm going to talk a little bit more about that, forms changes in a minute, but there'll be some changes, but nothing that's going to be earth-shattering for you guys. Maybe some things you don't like, but not earth-shattering. Buyer agency commissions must be disclosed. Again, something we do already, something we've done for a long time. So that's not going to be too big of a deal. And actually, I went through the commercial forms I finally finished doing some changes to those last night. They have a meeting today to approve changes to commercial forms. That will be something they're actually going to have to do a little bit better job on the commercial side that they don't do already. Just letting the seller and the buyer know what the split is going to be and making that mandatory instead of something that's not always shared with the parties. Buyer agent commissions must be agreed to by the buyer and cannot simply be subject to offers of cooperative compensation. What does that mean? It means that already in Form 201, the exclusive buyer agency agreement, the residential one, you guys are going to need to do a lot better job on something you are not doing a good job on right now. And if you don't learn to do a better job on it, get ready for a real big shock when July rolls around. Okay? Because if there's right now, way too many of you are already filling out that little line that says what you get paid in the exclusive buyer agency agreement. That line there, you're filling it out wrong. Okay? Way too often. And by you, I don't mean anyone on this call. You guys are clearly plugged in and in the knowledge, in the know. This is everyone else. When I say you, I mean the collective you, the collective realtor you. Certainly no one in this room. Or if it is you in this room, just don't tell me. Just pretend like you are exactly as excellent as I think you are. But In Form 201, the exclusive buyer agency agreement, there's a line that says what you're supposed to get paid. And right underneath that line, it says, do not put per MLS, do not put NA, do not put anything but a specific amount of money that can be specifically identified and calculated. This is your contract with your client for how much you are going to get paid to do a service. That is what it's always supposed to have been. And that's what it really, really, really needs to become. Because if there is no, what's been happening to this point is a lot of realtors been filling that section out wrong, and then they're saved because procuring cause, because cooperative compensation MLS, right? Well, that's not going to be there anymore. So if you fill that out wrong, if you don't have an agreement with your buyer, yes, you can work out cooperative compensation potentially with a listing agent, because what I hope is that listing agents and sellers are going to realize, either through hard knocks or maybe not through hard knocks, I'm not sure. But what they're going to learn is that buyer agents are extremely valuable. Buyer agents get their clients to closing. Buyer agents, yes, you advocate for the buyer. It's true, but it's not completely adversarial. And so to me, especially, right now, sellers are feeling a little bit fat and happy because, they don't have to work super hard to find buyers right now. That has not always been the case. Those of you who've been around for a while, a buyer market is coming. It will. Maybe it's not going to be soon. Maybe, who knows when. But it is coming. It will change. And so when that happens, buyer agents are going to show their value, to sellers then too, and to buyers. So what I would say is that, when it comes to the exclusive buyer agency agreement and getting an agreement with your client that makes sense, make sure that you are describing exactly what that value is to the buyer. Buyers are also going to need to understand that this is a service that is important, that they need to pay for. And they need to figure out how to pay for if cooperative compensation is either limited or something that they can't do. I will not sugarcoat it. In the short term, this is not going to be easy for buyer agents. It's just not. Mostly because in a perfect world, we would get some banking regulation changes that would allow the buyers to do what they're doing already, which is to simply roll their agent's fees into the mortgage package. That is not the case yet. And I don't know if that's going to be the case. My guess, if you were asking me, to predict the future, is that there will be changes for FHA and VA buyers in the short term. That seems to be more possible, or more likely, I guess, mostly because those particular groups, people are going to be sensitive to them. They're going to want to look out for the veterans. They're going to turn it into a political football. And I'm not talking about a particular party here. Both parties love to pick political footballs. So, don't feel like that's some kind of Democrat or Republican thing. It's not. To me, that's more. Those two things are more likely. And in particular, VA. I wouldn't be surprised if in this current climate, FHA buyers are left out in the cold too. But we'll see on that. As far as regular everyday buyers, it might just be something where enough horror stories get out there about buyers struggling to be able to get homes, and about how these, instead, a lot of these homes are being bought up by large corporations, continuing what is already a difficult housing market for first-time home buyers, and continuing struggles for the buyers generally because of the lack of inventory. I just wonder how much pressure there's going to build on that before change is actually made. It's probably going to have to be a lot more pain than what's out there right now. It's just my guess. I don't have a crystal ball, but if I was some, two-bit hack psychic, giving you guys some sort of guess, that would be my guess. Anyway, moving on. Number 5. Buyer agents are no longer entitled to keep commissions over and above what the buyer has agreed to pay. Those changes will come out in all the forms in July. So just understand that it doesn't mean that you can't work it out with your buyer client. In other words, if cooperative compensation can be worked out where the amount of cooperative compensation is more than what you've agreed to with your buyer, then you could amend your agreement and you could be able to keep that compensation. So that will be part of the forms changes that come, but just know that that's not like the end of the story. Okay. No advertising, buyer agent services are free. Again, that's something that's been around for a while, so hopefully that's not new to you guys. Seller has to approve of any cooperative compensation to a buyer agent. So interestingly, in the residential forms, in the exclusive listing agreement, Form 101, that's already in there. It's already specifically disclosed. We'll be doing a little bit of addition to that, but otherwise that's already in there. Commercial side, I've drafted changes to accommodate that. Hopefully those will be approved today. But again, not a huge change for us here in North Carolina. Agents must disclose that commissions are not set by law and are fully negotiable. Those words will be in the forms going forward. But again, a lot of the forms we have already have that specific notice already. So on the residential side, a little bit more, but on the commercial side, that notice was almost there verbatim already in those forms. Number 9, off MLS cooperative compensation buyer concessions will be allowed. Just has to be off MLS. The settlement will expire in 7 years. I have no idea what will happen then. These changes are, but just so you know, these changes are going to be around for at least 7 years. And these changes are going to affect July, but maybe later this year. Mostly, I put that in here because I don't know. Lawyers love getting extensions for things. So right now they're forcing me and everybody else to act as if it's definitely going to be July. Is it actually going to be July? We'll see. Right now, I'm acting as if it's July, and I'll be preparing everybody, that way. So, what's going to happen now? Like I said, forms changes. In particular, if you guys are not familiar with Form 220, Form 220 is the form that you would use if you were going to make an offer on some property outside the MLS that you're a member of, and you want to negotiate cooperative compensation with the listing agent. It's the form you would use that. Well, obviously that form is going to get real popular now. So we're going to do a complete rewrite of it to help protect you guys a little bit better. Make it a little bit more tailored to the everyday situation rather than a specific scenario where it's like where you're making offers outside your MLS. A lot of the language in there is not very user-friendly, so I'm going to try and make the language more user-friendly while also giving it some legal teeth that it doesn't currently have that you guys are going to want moving forward, especially if you don't have, I don't, talking about MLS rules and code of ethics rules. I don't know if arbitration is going to be around anymore. Honestly, I know. I have no idea what changes they're going to make to the code of ethics and the MLS rules. I don't know what the scope of those is going to be. And to me, there's a real question of whether, the arbitration will continue to be around or not. There's a real question of what will the code of ethics mean or be, without having to navigate cooperative compensation anymore. There's obviously a lot of the pieces of the code of ethics that address that and are meant to protect that. So I'll be curious to see how they navigate those things and what they choose to, put in there. We'll be working at the state level on education and training. That's already begun. So, you can look for that coming soon. It will be rolling out probably even before the July forms changes come out. So that'll be something that hopefully we'll be wrapping up a lot of it this month and then starting it next month. And as far as membership decisions and value, I think the one thing I want to say about that is hopefully, your local board, I think does an excellent job of giving you guys resources. That's just my personal opinion. I'm not a realtor. So, you guys are entitled to have what opinion you want, but it would not surprise me if by and large, most, of your members find value in a local, in the local board, in the Johnston County Association. It also wouldn't surprise me if most of you find value in the state association and the sorts of services it offers. And I'm not here to try and, preach about those sorts of things, but if you're asking me to rank, the things that those two organizations do very well, and they work hand in hand, is that there's number one, the political advocacy. If you guys are not aware of the political advocacy that goes on your behalf, it is constant. It is every day. For me, on my end, at the state level, I'm reviewing draft legislation. You guys may remember the MV Realty statutes that came out, last year. I think that's right. Um, yeah, I helped draft a lot of that. The reason it came and went for you guys, and you may not have noticed very much, is because you had people besides me looking out for you, because other interested parties were getting ready to draft that whole thing, and we were invited to the table and to be like, all right, well, how do we work with you guys to make sure that the good people are not punished, along with the people who are abusing a particular process? That sort of thing happens all the time. Especially if you are someone who does property management. I mean, that is constant. Landlord tenant issues are constant. Other pressures on your industry are constant. And sometimes you'll hear about things that are like small wins. I would consider small wins, like not having to pay your privileged license tax anymore. Okay, fine. But the things you don't hear about that I find to be a lot more impactful is you have at least two, probably three organizations just in the state and local level who make sure that your local politicians, who affect you more than anybody else, are people who are realtor advocates, and if possible, realtor champions, although you can't always get one of those, but at least getting people who will listen to us when they want to do things like short-term rental bans or whatever. Okay. That is a constant thing that is working on your behalf all the time. So if you're not familiar with your local GAD, get familiar with the local GAD, get familiar with local politics. These are super important things that, the organization does. And what I will say finally about NAR is this: I totally understand if you as a member feel frustrated with the way NAR handled all this. I have my own frustrations. I just do. But at the end of the day, I think that it'd be real hard for the way the state organization and the way JCAR operates. We use a lot of NAR support, and nobody's perfect. So if you're looking for someone perfect, don't get married. That's my personal advice. Free non-legal advice of the day. Nobody's perfect, and NAR's had a lot of struggles outside of this recently. And the way that this has been handled has not been my favorite. But at the end of the day, you just need to understand that a lot of the things that we do well at the state and local level are also with their support, monetarily, and with materials, with training, with just data. Listen, data is expensive. If you want just like an idea, like the Burnett case, that one invoice with an expert charging over $1 million, that's because of the processing of data. When one of the things the state level is looking at doing right now, not looking, it's in the process of doing already, is doing a heavy level marketing campaign. Well, the budget for that is very large, and it's because of data. It's because you've got to drill down and figure out, what are people thinking, what will people respond to. All that is to say, again, I'm not here to try and preach to you about why you should or should not, be a realtor generally. But what I will say is that before you decide to, go on a crusade to try and dismantle your NAR membership from all your other memberships, understand that that is one of the unintended consequences that may happen. And I'm not saying that it's not possible. I don't know what it's going to look like going forward. But what I will tell you is that the way things work now, they work because of the relationships that you have. So take that with a grain of salt, from someone who's not a realtor. I will tell you that I wish that the Bar Association had a similar structure and network, because I feel like as lawyers, we're under pressure much in the same way. But we don't have nearly the kind of voice that you guys have when it comes to politics. So just something to think about, and certainly something we can talk more about. Last thing I want to talk about is, why did NAR settle this case? Like, why, we heard about up until the Ides of March was that this appeal was going to happen, right? And they're getting ready for post-trial motions, which that happens, right? Whenever a trial happens, the next phase is not the appeal. It's post-trial motions in front of the same judge, where basically you ask the judge for a lot of different things. You'll ask the judge to set aside the jury verdict. You ask the judge to reduce the bond for the appeal. Now, understand, you guys may have heard a lot about Donald Trump and the bond and some of in his civil fraud trial, that resultant verdict. That's been in the news lately. And one of the things that to just make sure we're clear on, and maybe you got this from the news, but you don't need to post a bond to do an appeal. You can appeal, just by paying a couple $100. That's not the problem. The problem is if you don't pay a bond, if you can't satisfy a bond, then the collection efforts in a civil case can start immediately while the appeal's pending. So you may win the appeal, but now you got to go get your property back from the other side. So that was the big issue when it comes to, if you're looking at Trump's, case and wondering what the appeal bond was all about, that's what it was about. And the same thing with NAR is that, posting the bond, it's a very, very large bond. It was going to be a difficult ask. They were having to ask this judge to lower it. If NAR would have gone through with that and the judge didn't lower it, they would have had to do it, what Donald Trump did, which is ask the appellate court to do it. And then the appellate court did do it. And you may have heard in the news that that is an extraordinary measure. Like that is something that hardly ever happens. So just understand that, NAR could have done, similar routes, but chose not to because of, the different pressures that were going on. So what sort of, things went into the decision to settle? Number one, you may notice when I went through, these items, these 1 through 11 items, as far as what the terms of the settlement are, you may notice that a lot of those things have nothing to do with sellers, had to do with buyer agents. Well, why is that? I think the reason for that is because when NAR is looking at selling the Burnett case is not it. There's a bunch of antitrust cases out there with buyer plaintiffs. And in the buyer plaintiff antitrust cases, what the buyers are arguing is that I had an agreement with you, buyer agent, to pay you a certain amount of money to perform a service. And then you went in the MLS and you got more money than what I agreed to pay you, but I paid that. I paid it as part of the purchase price, and then you turn around and got more money than what I agreed to pay you in the agency agreement. So that's what those cases are about. And so that's why so many of those things in the settlement have to do with buyer agency agreements, because I think they are intentionally trying to head off more of those cases. And then finally, as far as the MLS rules and how far they go, that actually gets less to the Burnett case and more to what the DOJ has been saying. Because those of you who've been paying attention to stuff know that there's been ongoing things with DOJ ever since DOJ pulled out of the settlement that NAR had with them a couple of years ago, right? They're still there. They haven't gone anywhere. They just haven't been in front of faces because it's just been kind of in the background. But they're still there. And then right after we had this whole thing with the Burnett verdict, DOJ files a statement of interest in an MLS case in Pennsylvania. And basically indicating, we're getting ready to gear up again. Why? Probably because, and again, this is not political, this is not like partisan, it's not Republican or Democrat, but, when politicians can find an easy thing to get a splash of attention, they're going to do it. So if the DOJ can get a splash of attention for some politicians, then they're going to do it. And so that's what happened, I think, in the MLS case and why they chose to, finally get involved in one of these particular antitrust cases. The big verdict comes out, statement of interest. So you can see that the terms of the settlement also address some of the issues in that case, and what DOJ was asking for in their statement of interest in that case, which, by the way, the MLS case is also a civil case. So DOJ's statement of interest basically means that, hey, we're interested in this case, even though it's a private case between two parties, because it's an antitrust issue, we are interested in it. So to me, it makes sense for NAR to say, all right, the Burnett case, settling that is already going to be a real heavy lift. We have these other things floating out there. If we're doing a really, really heavy lift, if we're doing a seismic shift, then let's just do a seismic shift and get it all done at once instead of doing several. Okay. Is it going to be comfortable? No. I don't see anything about this that's going to be comfortable. Is it going to be insurmountable? No, I don't. I don't think so. I mean, some of you have probably been practicing long enough, and if you haven't, then I'll tell you. The whole reason we have buyer agency the way that we do, and the reason we have this MLS rule, was because back in the mid '90s, people were really upset, and there's bad publicity about seller sub agency. With people saying, we didn't even know that the person who is our buyer agent wasn't even our buyer agent; they were representing the seller. So this is something that is, to me, is similar. I think it's an opportunity for growth. And at the end of the day, I believe in what you guys do, which is cultivate relationships, and help people buy and sell houses. If you continue to do that, continue to be focused on that, yes, it's going to be difficult in the short run, but I don't think insurmountable by any means. And at the end of the day, people pay gross amounts of money for people to come and organize their closets for them in their houses. If you think that somehow they're going to magically have the gumption and organization to go and buy a house and not completely mess it up, well, I think you have more faith in those people than I do. So anyway, I'm going to leave you guys with this. This is the information for the legal hotline. If you don't know about it yet, the legal hotline is a free member service for realtors. If you're a realtor member, it's a free service to you. We will help you with forms, questions. We will help you with all sorts of questions. You guys are very, very, very creative with the kinds of questions you ask. And it's something in this department. We can give you general advice, give you general information, usually help you out in a way that gets you put on the right path. One of the things I'm going to be talking about this year to every group I talk to is make sure you understand the difference between the realtor hotline, which ranks to our law office. You are going to get a lawyer. You are not going to get a paralegal or something like that, which is a big difference between us and the regulatory affairs line at the commission. If you want to talk to the commission, by all means, do it. But understand, like what I said earlier, what their mission is. Their mission is to protect consumers. That is the kind of focus they're going to have. And so understand that sort of advice has a completely different focus and goal than it does for us. Our job is to look out for realtors. That is what we do. So just understand the difference on those two things. And if you're a BIC, please make sure your agents understand the difference. There's been a couple of phone calls I've gotten where agents have gone to the commission first before calling our hotline. If they would have called us first, they would have got a lot different answer. So anyway, thank you for inviting me out today. And I don't know what kind of timeline we're on, but if there are some questions, then we can do some questions, Madam President.
Thank you so much, John. That was good information. I will tell you, I never made the connection for the Ides of March. And for some, they thought that was going to be the end of our industry. And for others, it was like Armageddon. But with information that you're presenting today, we know that we have to make certain adjustments in this business. There's certainly a shift in how we present to especially our buyers and set that expectation for them. So I appreciate all the information. I know that I'm much calmer now that I've obtained all the information pertaining to, and especially the backstory for this lawsuit. So Bonnie, do we have any questions? I'm going to check the chat really quick. One question here, John. And it reads, any anticipation of adjustments, shifts in pricing for residential real estate? I know with CNN, I believe it was, the idea is that home prices are going to go down. Sellers are going to save 2.5%, 3% because commissions are fixed. I mean, I'm pretty sure you saw the storylines. So if you can just chime in and give us your input on that, please.
Yeah. So I had a really interesting discussion with my law partner, Adam, on this. So I have two law partners. Some of you may know my partner, Will Martin, who retired. He was somewhat infamous, and I am the slightly dumber but better looking version of him and younger. But, my two partners I have now are Bill Gifford, who's also been doing this a long time, and then Adam Stallings. Adam used to be a lawyer with the Real Estate Commission before he came to private practice, and now he does mostly defense work in the Real Estate Commission. Um, I had a really interesting discussion with Adam though on the mathematics of this, and right now, to me, it if you do the math, I don't know how it's going to affect home prices. I'm just going to tell you how the math makes sense to me. But are home prices going to go down 2.5%? No, no. I don't see how they could or are. I don't think that the I think when you have listing agents out there, they're going to price the home based on square footage. And then, yes, the commissions are sort of like a cost of doing business, but it's not the actual value of the house. It's not an appraisal. So to me, I'll just be very curious to see in the short run whether there's any impact at all. Could there be in the long run? Yes. But that is going to take buyers finally reducing the amount that they're offering, because when you are offering making an offer on the home, it includes already the commission is already wrapped into it right now. So I actually think that you're not going to see that much of a push, but I don't know. To me, when I talk about the math and it's just not a simple of backing out of whatever the buyer agent commission is, because that's going to be the buyer's cost. And now it's going to be upfront instead of paid over time as part of a mortgage package. And if you think about it, I guess this is just me, but I might be a nerd about this. But if I was a buyer and I'm looking at this and I can't pay my agent, let's say I just don't have enough money to pay my agent cash up front, okay, my buyer agent. I want an agent and I'm making this offer. And the seller says, too bad, you're paying your own agent. All right. I'm not doing cooperative compensation. All right, fine. Well, if I was paying for my agent as part of the loan package, it would cost me, let's say, $30,000 instead of 15 cash up front, right? Because I'm paying it as part of the loan. Interest is attached to it, right? So if I'm adjusting my offer as a buyer, then I'm going to back out a lot more than what I was going to pay my agent up front. Instead, it would be that plus interest. So, is that actually going to happen? I just can't imagine it. But, to me, that's how the math would work if it was, well, especially if it was a buyer market right now. I think that's actually the biggest X factor to me is what kind of market is it? Seller versus buyer. Who's really in the better bargaining position? Right now, seems to be sellers in most places. So if it's sellers in most places, then then I just don't see how they are necessarily going to be paying less. If they want to be able to attract a buyer who's going to have an agent help them to get to the closing table. But who knows? I could be wrong. I will tell you that the economic experts who get paid to have opinions on this stuff, they do believe that the overall seller costs are going to go down. Does that mean the value of houses is going to go down? I don't know. To me, that seems to be a pressure more from these other factors like affordability, interest rates, availability of housing, just general inventory, things like that. So anyway, I'll be curious to see how it happens, but I don't have anything, I don't have any crystal ball on that.
Okay. Thank you for that. We have a couple more questions here. The next says, please repeat the two rules that you'd like to see change with the commission.
Well, I think it's already the case that commissions are already part of the transaction between the buyer and the seller, right? The buyer and the seller already have to navigate commissions in their respective camps. Right now, by rule, you can't use a pre-printed offer to purchase a contract that addresses commissions in the contract. Other states do this. It is not something that no state does. There are states that allow you to negotiate the actual agent commissions in the offer to purchase a contract itself, and to negotiate cooperative compensation if there's going to be any or not. And to me, right now, you're going to have to do it as part of a two-step process. As far as negotiating property compensation as part of the transaction. And I think it's going to be inefficient. I think it makes a lot more sense, and I think it makes the numbers a lot more sense to just put it into the contract itself. The reason the commission says that it doesn't want agent commissions to be in a pre-printed offer to purchase contract is because they don't want the buyer and seller to be part of a commission dispute. But that doesn't make any sense to me because the parties are the ones paying the commissions. And if you sort out how they're splitting the commissions, how are you putting yourself in the middle of a dispute? There is no dispute. It's a contract. So to me, I don't understand the inefficiency of this, and I don't understand how this inefficiency actually benefits consumers, especially when buyers are going to have a real hard time getting representation. You are hurting buyers by not doing this, and you're not really helping sellers that much either by making sure that buyers don't have access to representation. So to me, it's just one of those things where I don't understand. I think it's something that should be looked at a little bit more closely and examined. The other rule is shopping of offers. Again, other states allow this. To me, it makes more sense that if we're going to pay you to be professionals, then part of your professional judgment should be whether you can shop an offer or not. And especially if your client consents to that. So those two rules, again, this is just my personal opinion, it is not an attack on the commission. I will repeat, those two rules. I'm not saying get rid of them or anything, but I'm just saying, maybe take a closer look at them and see if they actually make sense with respect to practice as it operates in the industry. Is it efficient or not? We already have enough inefficiencies built in. Are these inefficiencies actually helping consumers or not?
Okay. Thank you for that. Questions are rolling in. And of course, they're primarily centered around commissions. So if you could just briefly touch on antitrust and the discussion of commissions. We put out an infographic recently about the do's and don'ts of who, in what setting can you discuss commissions? For example, we're prohibited from discussing commissions like on social media with someone of another firm. I think some of that kind of put us in the spot where we are. I've seen a lot of activity on social media, and I'm like, perhaps they should consult their bigs. But if you can discuss commissions and what settings we should be discussing commissions, especially at this juncture.
I think when it comes to discussing commission rates, it's probably not ever really a discussion you want to have. You got to understand, like, part of a restraint of trade analysis in the antitrust context, like for an antitrust case, there's this thing called tacit collusion. Tacit collusion basically means, like, think of a flock of birds, they all fly together, right? They're all completely independent, but they're all, flying together, same direction, changing direction immediately, things like that, right? That is probably how tacit collusion works. And tacit collusion, if it is occurring, can be unlawful restraint of trade. So certainly discussions don't help. What they do is provide evidence of that, but just understand it doesn't have to be a discussion at all. It doesn't have to be a cigar, smoke-filled room somewhere where you guys sit around and talk about what you're all going to decide to charge together. So I would just say this: when it comes to commission rates, look at what your value is, and as a firm, and determine what that value is and how you want to operate. And I think if you take it that way, yeah, sure, there's going to be some overlap. There's going to be some probably some sort of level where things are pretty equal or even or whatever. But if you're making that decision independently based on your own business model, then to me it's kind of hard to argue that there's something going on there. Basically, what it is to say is that discussions, no, don't have them, not with each other anyway. I see a question here about Article 16 and how and the contingent, not making an offer contingent on cooperating compensation. Yeah, I think that rule, it's got to, something's got to change with that. I just don't. I I don't know what the rule changes are going to be as far as the code of ethics go, but and nobody's asked me what I think those changes should be. But if you're asking me, yes, the prohibition on an offer being contingent on cooperative compensation, to me, uh, it seems like that's got to be something they got to look at as far as changing. We'll see.
Okay. Okay. I think that will do it, John. We certainly appreciate your time. And feel free to come back and chat with us any other time. So there are no more questions. This recording, just want to announce that this recording is available via the on our NAR settlement and commission practice changes information hub. So this recording will be available there for any of us who want to go back and refer to it. And certainly the one thing, especially the one thing, the highlight of this call for me is the Ides of March. I never made that connection, but I will not look at it differently. Look at it the same. From this point forward. So everyone, John, thank you for your time. Um, our members, thank you for your time in coming out to this pop up event. So I hope it was beneficial to you and your businesses. Thank you all, and have a great day. Bye bye.
Thanks for having me.